So today we will be analyzing various course outlines, and I'll be starting with sharing my screen so that you can see various course outlines that were shared by the institution, the Kenya School of Law, the course outline for the year 2026 all the way to 2027. Let me enlarge the screen. Okay, this is it. So if we were to start with, we were basically expected a look at the teaching and instructional objectives. Let me confirm it is recording. Yes. We were the institution was to ensure that students understood the practical application of the Civil Procedure Act and the Civil Procedure Rules of 2010 made thereunder, the Court of Appeal Rules 2022, the Supreme Court Rules 2012, and related statutes. And it also to ensure that a student has a firm grasp of the multifaceted rules of the Civil Procedure 2010 and other rules of court and how they apply in Kenyan courts. I remember in April 2026 paper, they tested on an application of 52B, an application where you seek stay of execution, but now you're seeking the stay of execution at the Court of Appeal. And this was a difficult thing to do because many students will approach this question with Order 46 Rule 2 of the Civil Procedure Rules. But we had a difference when it comes to the ground that this student ought to rely on, because once we analyze the Order 52B, we realize that there is a shift. It is not the common grounds that you will apply with when it comes to Order 42 Rule 6, but there are other grounds. So this analysis of the Civil Procedure Unit will also give us a room to look at how I dissected the Civil Procedure Code in a brief manner, because I have to highlight the various key important topics in making reference to the same. So generally, project work will form 20%, oral examination 20%, and the final written examination 60%. So topic 2 was on taking of instructions in civil litigation. This is where we were taken through advocate interview and conferencing. We were taught how to write a legal opinion. We were taught how to do the decision to litigate or not to litigate. And then we have pre-litigation preliminary considerations. We have the cause of action. We have jurisdiction. We have res judicata and sub judice. We have limitation of actions and feasibility of lawsuits, and even ethical considerations before taking up a case and ethical consideration after taking up of a case, and how to draft a demand letter. So because I've said that, let me show you something. We have to analyze what topic 2 entailed in a researching manner. So this now begs the question of, let me share my whole screen. I believe it will allow. Okay. It is not sharing. Okay, so what can I do? Okay, maybe the screen can project on your end because the recording will have the steps that I'm following in doing the research, because I'll just be reading through. So to avoid a situation where the screen is disappearing, let me continue sharing the same while I do the research in my background tab. So I've said we are in lesson number 2, and in lesson number 2 we can see various aspects arising. We can't ignore the issue on res judicata and sub judice, even in orals. Res judicata and sub Judy's Kenya Law Report. You have to understand what forms the basis of what amounts to res judicata. So res judicata under the Kenyan law is guided by the Civil Procedure Act, and these are doctrines designed to prevent the abuse of court processes, but they operate at different stages of litigation. For instance, res judicata is provided under section 7. Okay, and what it means is that a matter that has already been conclusively decided, it prevents relitigation of the same issues. So remember, there is a rule that no court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit. So there are some key requirements that the examiner or the panel will expect the student to cite. It must be between same parties or their successors or representatives. It should involve same subject matter and cause of action, or the previous court was competent to hear and determine the suit, and the matter was heard and finally decided on its merits. Now this begs another question. Let us read the interpretation. I'm in fact opening the analyzed civil procedure rules that I label as section A, so that we see what if a person has filed a lawsuit in a foreign country. Is that a competent court? So let us read in verbatim, because there is an exception that students will fail if it is tested in an exam situation. So I'm rushing through quickly. Order, sorry, it is Civil Procedure Act, not the rules. Civil Procedure Act. Civil Procedure Act. Let us go through the section 7 on res judicata. Section 7. Sections. Good. Res judicata. So to read it in verbatim. No court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties, or between parties under whom they or any of them claim, litigating under the same title in a court competent to try such subsequent suit, or the suit in which such issue has been subsequently raised and has been heard and finally decided by such court. So the Act continues to give various explanations, where number 1, the expression former suit means a suit which has been decided before the suit in question, whether or not it was instituted before it. Okay. Explanation number 2, for the purposes of this section, the competence of a court shall be determined irrespective of any provisions as to the right of appeal from the decision of that court. And explanation number 3, the matter above referred to must, in the former suit, have been alleged by one party and either denied or admitted expressly or impliedly by the other. Explanation number 4, any matter which might and ought to have been made ground of defense or attack in such former suit shall be deemed to have been a matter directly and substantially in issue in such suit. Explanation number 5, any relief claimed in a suit which is not expressly granted by the decree shall, for the purposes of this section, be deemed to have been refused. Explanation number 6, where persons litigate bona fide in respect of public right or a private right claimed in common for themselves and others, all persons interested in such right, for the purposes of this section, be deemed to claim under the person so litigating. So there is a bar to further suit pursuant to section 8, where plaintiff is precluded by rules from instituting a further suit in respect of any particular cause of action. He shall not be entitled to institute a suit in respect of that cause of action. Okay. Elections. looking for that. Okay. The point that I was making was in section 6, stay of suit. Okay, so no court shall proceed with the trial of any suit or proceeding in which the matter in issue is also directly and substantially in issue in a previously instituted suit or proceeding between the same parties or between parties under whom they or any of them claim litigating under the same title, where such suit or proceeding is pending in the same or any other court having jurisdiction in Kenya to grant the relief claimed. This is where I have the explanation on the foreign courts. The pendency of a suit in a foreign court shall not preclude a court from trying a suit in which the same matters or any of them are in issue in such suit in such foreign court. So you can't say that because this matter is being litigated in a foreign court that this court will have to stay this suit. Okay, so that is the rider that I was trying as much as possible to capture. Then if we go back to understanding now sub judice, that is a direct interpretation of sub judice provided under section 6, the words that I've directly read. So what it means by sub judice is a matter pending trial. It bars a court from trying a case that is already ongoing in another competent court. And no court shall proceed with the trial of any suit or proceeding in which the matter in issue is also directly and substantially in issue in a previously instituted suit. Remember, for sub judice, the matter is ongoing in a concurrent court with a competent jurisdiction. Remove the foreign courts angle. But now another rider that I also wanted to focus on is where we have a matter that has been dismissed for want of prosecution. If the matter is dismissed for want of prosecution, if you refile that matter, that will be res judicata, unless you set aside the judgment or the ruling that dismissed that matter. But if the matter was struck out, okay, because the plaintiff did not disclose a cause of action, okay, you can always refile because that matter was never determined or heard by its merits. That is a clear distinction between the two. So in sub judice, there are key requirements that the examiner will expect to see, or the panel. It must have same parties or their privies, or same matter directly and substantially in issue, and that the previously instituted suit is still pending and active in a competent court. If it is a foreign jurisdiction, then nothing bars our courts from proceeding. Okay? So what are the comparisons at a glance between the two? You can be told by the panel. Can you give us 3 differences between res judicata and sub judice? So status and previous case, that is 1. In res judicata, the previous case was concluded and finalized. In sub judice, is still pending and active. And action taken in res judicata is that the suit is dismissed entirely, but in res sub judice, the subsequent suit is stayed or paused so that the other one will take precedence. Primary purpose between the two. Res judicata is a finality, one bite at the cherry. But if you look at the sub judice, primary purpose is to avoid contradictory rulings and conflict in decisions. So that was it. Then let us look at limitation of actions. Limitation of actions, the examiner expects the students to have read the Limitation of Actions Act. Okay? Of Actions Act. Do you understand that this, from what I'm carrying on, or from this fact, am I allowed to file a suit? Am I allowed to file an employment matter? Okay. So let us have a look at Limitation of Actions Act in a brief manner. And I will start with section 4 because it is falling under part 2 on periods of limitation. And actions of contract and tort and certain other actions. So the following actions may not be brought after the end of 6 years from the date on which the cause of action accrued. Okay, so you can't bring these actions after the end of 6 years. from the date on which the cause of action accrued. 1. Actions founded on contract. 2. Actions to enforce a recognizance. 3. Actions to enforce an award. D. Actions to recover a sum recoverable by virtue of a written law other than a penalty or forfeiture or sum by way of penalty or forfeiture. Actions including actions claiming equitable reliefs for which no other period of limitation is provided by this Act or by any other written law. Section 4 still provides that an action founded on tort may not be brought after the end of 3 years from the date on which the cause of action accrued. So actions founded on tort may not be brought after the end of 3 years from the date on which the cause of action accrued. The same subsection provides that, provided that an action for libel or slander may not be brought after the end of 12 months from such date. Okay, so key takeaways: contracts by the end, you can't bring after the end of 6 years. And then another key takeaway we have, when it comes to torts, you can't bring a tort after the end of 3 years. And for libel and slander, you cannot bring them after the end of 12 months. 3. An action for an account may not be brought in respect of any matter which arose more than 6 years before the commencement of the action. 4. An action may not be brought upon a judgment after the end of 12 years from the date on which the judgment was delivered, or where the judgment or a subsequent order directs any payment of money or the delivery of any property to be made at a certain date or at recurring periods. The date of the default in making the payment or delivery in question, and no arrears of interest in respect of a judgment debt may be recovered after the expiry of 6 years from the date on which the interest became due. 5. An action to recover any penalty or forfeiture or sum by way of penalty or forfeiture recoverable by virtue of a written law may not be brought after the end of 2 years from the date on which the cause of action accrued. Okay, so that is an action to recover any penalty or forfeiture or sum by way of penalty or forfeiture. Okay, you can't bring the same after the end of 2 years. This section does not apply to a cause of action within the admiralty jurisdiction of the court which is enforceable in rem, except that subsection 1 of this section applies to an action to recover seamen's wages. Okay. Then let us look at other angles that the examiner can use to confuse a student. We have actions to recover land, pursuant to section 7. An action may not be brought by any person to recover land after the end of 12 years from the date on which the right of action accrued to him, or if it first accrued to some person through whom he claims to that person. Then actions to recover rent, pursuant to section 8. An action may not be brought and distress may not be made to recover arrears of rent or damages in respect thereof after the end of 6 years from the date on which the arrears became due. Okay. Then we have section 10A on special time limit for secondary liability of partners. An action to hold a partner personally liable under the law relating to partnerships for a partnership obligation may not be brought after 1. The date of the expiration of the period of limitation, if any, applicable under this Act to an action against the partnership in respect of the partnership obligation, or B, if the date of judgment against the partnership establishing the partnership obligation is after the date referred to in paragraph 1, 2 years after that date, because subsection 1b applies whether or not there is an appeal against the judgment and whether or not execution of the judgment is stayed. in subsection 1 applies to a former partner as it applies to a partner. Remember, this is a key provision, and the same will be applicable in our analysis of the LLP Act, General Partnership Act, and the Companies Act. Okay, these are very critical part, and we have not discussed the same. Okay, what other thing should you be keen on? What other thing from this act should you? There are various angles where the section 26 allows for extension of limitation period in case of fraud or mistake. Okay, so where in the case of an action for which a period of limitation is prescribed, either 1. The action is based upon the fraud of the defendant or his agent, or of any person through whom he claims or his agent, or the right of action is concealed by the fraud of any such person as aforesaid, or C. The action is for relief from the consequences of a mistake. The period of limitation does not begin to run until the plaintiff has discovered the fraud or the mistake, or could, with reasonable diligence, have discovered it. Provided that this section does not enable an action to be brought to recover or enforce any mortgage upon or set aside any transaction affecting any property which, in the case of fraud, has been purchased for valuable consideration by a person who was not a party to the fraud and did not at the time of the purchase know or have reason to believe that any fraud had been committed, or, in the case of mistake, had been purchased has been purchased for valuable consideration after the transaction in which the mistake was made by a person who did not know or have reason to believe that the mistake had been made. Okay. Section 27 continues to tell us that extension of limitation period in case of ignorance of material facts in actions for negligence. This was tested in 2019. Section 4 does not afford a defense to an action founded on tort where 1. The action is for damages for negligence, nuisance, or breach of duty, whether the duty exists by virtue of a contract or of a written law, or independently of a contract or written law. And B. The damages claimed by the plaintiff for the negligence, nuisance, or breach of duty consist of or include damages in respect of personal injuries of any person. The court has, whether before or after the commencement of the action, granted leave for the purposes of this section. I'm looking at an application for leave of court under section 27. So an application for leave of the court for purposes of section 27 of this act shall be made ex parte, except insofar as rules of court may otherwise provide in relation to applications made after the commencement of a relevant action. Where such an application is made before the commencement of a relevant action, the court shall grant leave in respect of any cause of action to which the application relates. Okay. We have provisions where injured person has died. There is a point that I'm looking for when it comes to personal injury claims. Personal injury claims. Right, where is it? I'll confirm the same, because for personal injury claims you can seek an extension of time. For employment matters, you cannot seek extension of time after 3 years, and there is a court of appeal decision to that effect. So those are the key takeaways when it comes to the Limitation of Actions Act. Then, as we still continue to discuss various aspects of the cause outline, we take a look at topic 3 on courts and jurisdiction. We have to look at the jurisdiction under the Constitution and relevant statutes. The student ought to understand the statutory provisions for jurisdiction, geographical and subject matter, and also pecuniary, and the consequences of lack of jurisdiction. Then the overriding objective in civil litigation. What is the concept of the overriding objective? The role of parties and their representative advocates under the concept of overriding objective. Application of the overriding objective principle in civil litigation. So these are the key takeaways. You can be asked in orals to give various overriding objectives. In civil litigation. So generally, overriding objective in civil litigation is a foundational legal principle that requires courts to deal with cases justly, expeditiously, and proportionally. It prioritizes substantive justice over strict technical adherence to procedural rules, ensuring that disputes are resolved affordably and efficiently. In Kenya, this is often referred to as the oxygen principle because it breathes life and fairness into the legal process. And the legal framework generally operates on 3 core pillars. We have the primary goals on proportionality, expedition, and equality. We have duty of the courts, we have duty of parties and advocates. For the Kenyan context, I will have to see what the civil procedure provides when it comes to this overriding objectives. Okay. Criminal law report. So section 1A and 1B of the Civil Procedure Act outlines that court must interpret rules to give effect to the overriding objective. It mandates that advocates and parties are legally bound to assist the court in furthering these objectives. If you read the Appellate Jurisdiction Act, it similarly applies the overriding objective to civil appeals, encouraging courts to avoid striking out matters over minor or excusable procedural delays. If you read Article 159(2)(d) of the Constitution of Kenya, it empowers courts to administer justice without undue regard to procedural technicalities. And the various key principles that emanate from this doctrine is we have proportionality. Cases must be handled in a way that corresponds to the size, complexity, and financial importance of the dispute. Then substantive justice is where we have the rules of procedure are treated as the handmaid of justice, not the mistress, meaning that a legitimate claim will not be thrown out solely due to a minor or non-prejudicial administrative error. And lastly, we have expediency and cost. Courts manage cases to prevent undue delays and to keep the cost for litigation as affordable as possible. Okay. There are some decisions to this effect. Let me see how the court has interpreted the same. So here the court says that the overriding objective in civil litigation is a policy issue which the court invokes to obviate hardship, expense, delay, and to focus on substantive justice. So the enactment of Section 3A and 3B of the Appellate Jurisdiction Act and later Article 159(2)(d) of the Constitution changed the previous position, because the former provisions introduced the overriding objective in civil litigation in which the court is mandated to consider aspects like the delay likely to occasion the cost and prejudice to be suffered by the parties. So those were enacted pursuant to historical injustices in the judiciary sector. Critique the reason for the inclusion of the overriding objective in the Civil Procedure Act. Explain the application of overriding objective in civil proceedings. Then you have topic 5 on parties to a suit. You have introduction, joinder of parties and misjoinders. You have plaintiff, claimant, applicant, defendant or respondent. You have third party, you have interested party, you have interpleader, you have garnishee, you have attorney general, amicus curiae, representative suits, minors and persons of unsound mind. Key takeaway from this part is to look at interpleader proceedings in Kenya. Let us look at various interpretation of the same and how you will approach court in seeking for interpleader. Okay, let us see whether the articles will prove. Okay, so this is an article that was written by a law firm, KN Njega LLP, and it's a very substantive one, understanding interpleader proceedings. So it tells us that a person may find themselves in an enviable position of holding property that is subject of competing claims. The stakeholder in such a scenario does not own the property, but merely has possession or custody of it, yet risks being sued by multiple parties if they release it to the wrong claimant. Okay, so that is the introduction part, so that you understand what we are dealing with. And what does the law say? In such circumstances, the stakeholder is not permitted to remain passive. Rather, they are obliged to move the court by way of an application for interpleader proceedings, so that the rightful ownership of the property may be determined between the rival claimants. The purposes of this procedure is not to adjudicate the stakeholders' rights, but to relieve them from the burden of multiple claims and allow the court to settle the dispute directly between them. Under Order 34, Rule 2 of the Civil Procedure Rules, a stakeholder who seeks to institute interpleader proceedings must satisfy the court on certain conditions: that they have no personal claim, that the stakeholder must demonstrate that they have no interest in the property other than claim for lawful charges or fees associated with its custody, for instance, garage storage fees, warehousing charges, or mortuary fees. The interpleader must show no collusion. The stakeholder must show that they have not colluded with any of the competing parties in order to manufacture or perpetuate the dispute. Then you should show readiness to release the property. The stakeholder must be willing and ready to deliver the property to whichever party the court declares to be the rightful owner. And the risk of multiple liability is another aspect. The stakeholder must show that they are either actually being sued or are under a real and a reasonable apprehension of being sued by the competing claimants. Okay, so key takeaways. It is found under Order 34 Rule 2 of the Civil Procedure Rules. You have to show no personal claim, you have to show there is no collusion, and readiness to release property, and risk of facing multiple liability. Then the article continues to tell us, how do you approach court in an interpleader proceeding? Where no suit has yet been filed between the competing claimants, the stakeholder may approach the court by instituting interpleader proceedings through an originating summons. Okay? The procedure is governed by the general form of originating summons inter partes, namely Form 26 of the Civil Procedure Forms. In such proceedings, the stakeholder is designated as the plaintiff, while the rival claimants are joined as defendants. The originating summons seek the court determination of specific questions. 1. Who between the defendants is the rightful owner of the disputed property? And 2. Who ought to compensate the stakeholder for any charges or fees properly incurred before surrender of the property? Because of this unique nature, the application does not need to be supported by detailed grounds in the manner of a notice of motion or chamber summons. Instead, any supporting material is presented through a supporting affidavit. So you attach originating summons and a supporting affidavit that has been sworn by the stakeholder, which accompanies the originating summons. So this affidavit, the examiner will check, does it set out the following? Does it set out the fact of possession, the competing claims that are being made, the absence of collusion, the stakeholder's willingness to release the property to the rightful party, and the risk of multiple liability? Because those are the tests required under Order 36 Rule 2. Okay? Where there is already a suit in place. Where there is already a suit in place. Remember, if there is no suit, you approach through originating summons. Instead, the stakeholder does not file a fresh originating summons. Instead, they move the court by way of a chamber summons supported by a supporting affidavit. So this is where the examiner will be keen. You have been told there is a suit, and you still go using originating summons. Okay? So the court will then determine the rightful claimant within the suit and discharge the stakeholder once the property has been deposited or dealt with as directed. If the claim is made in suit by a defendant, the proceedings are stayed pending the full determination of the claim. Okay, so those are the key takeaways when it comes to interpleader proceedings. What have various institutions said when it comes to garnishee proceedings? What are garnishee proceedings? And how do you approach court garnishee proceedings in Kenya? So generally, garnishee proceedings in Kenya are a legal enforcement mechanism used by a decree holder, also referred as the judgment creditor, to recover money owed to them. Instead of seizing physical assets, the creditor attaches funds belonging to the debtor held by a third party, who is known as the garnishee, such as a bank or mobile money provider. So generally, these proceedings are governed by Section 44 of the Civil Procedure Act and Order 23 of the Civil Procedure Rules. The process requires the third party to redirect funds directly to the decree holder to satisfy a court judgment. So a good example that I can give you, let's say you have a personal injury claim, RTA, road traffic accident. You have won your case and you have sued a certain insurance X. And because you have the bank details of insurance X, or you have an insider of a person who has given you their bank accounts, okay, you will move court through garnishee proceedings. You are telling the third party, who is the garnishee, hey, the bank, this is the account number in your custody. There is 9 million in this account, but this person owes me 8.5 million. So kindly release this money to me through a court order. Okay, that is the basis. What is the three-step legal process in this situation? The decree holder files a court application supported by an affidavit demonstrating that unsatisfied court decree exists and that the garnishee holds funds on behalf of the judgment debtor. If successful, the court issues an order nisi. This is a provisional order directing the garnishee to freeze the identified funds and appear in court to show cause why they should not pay the judgment creditor. Then, on the mentioned date, the garnishee appears in court. If the garnishee acknowledges the debt order to the debtor and does not dispute it, the funds are usually earmarked. If the garnishee disputes their liability, e.g., claiming the customer's account is overdrawn or the funds do not belong to the debtor, the court may order a trial to resolve that specific dispute. Then you have order absolute. Once the court is satisfied, it issues an order absolute. This final directive legally compels the garnishee to release the funds directly to the decree holder or into court to satisfy the debt, protecting the garnishee from further liability. What are the various exceptions that you have to take note? Garnishee proceedings do not apply to the government of Kenya or state organs. To collect a debt from the government or a statutory body, creditors must strictly follow the Government Proceedings Act. Garnishee cost. The court may grant the garnishee a small or fixed amount to cover for their legal cost for attending proceedings, which is deducted from the judgment debtor's funds. Then, on mobile money, with the digitization of finance, Kenyan courts have increasingly granted garnishee orders to attach funds held in mobile money merchant accounts such as Safaricom and M-Pesa tills. Okay. So if you have followed the key amendments that are being introduced by the Finance Bill of 2026, you will have to take note of the change on tax procedures, where the Commissioner of Domestic Taxes will not be forced to issue you a notice of payment. Instead, they have the right to go directly to your employer, issue a notice, and then say that you have declined to pay to sort for government revenues in taxes formats. So previously you were supposed to be given an agency, not an agency, a notice from the commissioner, but they are bypassing the same notice to you, and they can use third parties to whom they believe that they have the funds on your behalf. And the law still will provide that the money will be released to them. Then you will take a dispute if you are challenging that amount to court. So it has changed the previous position in that with an agency notice where they have used now the third party, the agency notice has been served, and then before the money is released, you had time to rush to court. But in this situation, the money will be deducted first, then you will complain later. That is how they have tried to beat around that requirement. So I'm trying to look at what is the enabling document to use when you are filing for garnishee proceedings, to avoid a situation where it will come to our exams and we don't know the correct document to use. So Order 23, Rule 4 of the Civil Procedure Rules, execution against a garnishee. This is now execution part. I'm trying to look at, remember, any party is allowed to unmute, assist where possible. Okay, let me see this decision. Safaricom PLC being the garnishee in this situation. Somebody sued Safaricom. Let me open the decision so that we see how the parties moved the court. My laptop is freezing. Okay. There is an article written by Wamai and Allen advocates. Let me see. What does the law say? What does the law say? So generally the article provides that Order 23 Rule 4 of the Civil Procedure Rules systematically sets out the execution procedure against a garnishee as follows: that if the garnishee does not dispute the debt due or claimed to be due from him to the judgment debtor, or if he does not appear upon the day of hearing named in an order nisi, then the court may order execution against the person and goods if the garnishee to levy the amount due from him or so much thereof as may be sufficient to satisfy the decree, together with the cost of the garnishee proceedings, and the order absolute shall be in form number 17 or 18 of the Appendix A. Let me look at how I interpreted Order 23 Rule 4 of the Civil Procedure Rules. So let me rush to this part. Order 23, order 10. Let me rush. Order 1. This is order 1. Let me freeze. Let me move as fast as possible. Remember, these are full digest of the Civil Procedure Rules. Okay. It is very detailed, but if you break it down, you will appreciate various applications to draft and in what situations and the rationale of why you are doing a certain thing. Yesterday I finalized on the SOPEC rules, analysis of the SOPEC rules. I've even inserted decisions that emanated or gave rise to various tests that you have to consider for various parts. So we have a lot of material to cover, but the time is a bit constrained. But luckily we have decided to use a mode of revision where it is straight to the point, and we are avoiding as much as possible to read an irrelevant materials, because if the material is not provided in the course outline, we will consider it irrelevant for purposes of the examination, having the background that CLE and KSL have now merged in an MOU. Almost order 23. Did I analyze garnishee proceedings? Order 23. Order 23. This is order 22. Analyzed. I've drafted the notice of motion. When court may stay execution, order 22. I'm looking for garnishee. Nilifika huko kweli. Order 23, order 23. Attachment of debts, that is the topic for order 23. And it says that order 23, a court may, upon the ex parte application of a decree holder, and either before or after an oral examination of the judgment debtor, and upon affidavit by the decree holder or his advocate, stating that a decree has been issued and that it is still unsatisfied, and to what amount, and that any other person is indebted to the judgment debtor, and is within the jurisdiction, order that all debts other than the salary or allowance coming within the provisions of order 22 rule 42 owing from such third person called the garnishee to the judgment debtor shall be attached to answer the decree together with the cost of the garnishee proceedings. Okay, that was the introduction part of the garnishee documents, and we have seen that you will approach court through an application ex parte, so a notice of motion will suffice. Okay, good. So that is it. So luckily we can say that we now understand what amounts to garnishee proceedings, the test that you have to lay for garnishee orders, in the case of Morris Munya versus CFC Stanbic Bank 2019 held that the garnishee was not a judgment debtor. The decree was not issued against it, hence there was no lawful basis for attachment of the garnishee's personal property. If there was a delay or refusal to obey the court order of the court by the garnishee, the proper route is to pursue would have been contempt proceedings and not attachment. So this gave light to individuals who are going after the garnishee after failing to adhere to the court's order. So there are some individuals who attempted to attach the garnishee properties, and further this amounts to trespass, because this blog continues to say that the wrongful attachment of the garnishee property amounts to actionable trespass. A claim for damages can be successfully brought against the auctioneer, who in turn may seek indemnity from the advocate who applied for the warrants of attachment instead of the correct garnishee order absolute. The auctioneer can also be subjected to disciplinary proceedings before auctioneer's licensing board. So you have to apply for garnishee absolute. So that is it. We have seen the various stages of this procedure, and we are satisfied. What are third-party proceedings in Kenya? How do you distinguish between third-party proceedings and representative suits? In third-party proceedings, you have to seek a leave of court to serve the notice, the third-party notice. In representative suits, you must serve the persons to whom you intend to represent. So third-party proceedings in Kenya allow a defendant to bring an entirely new party into an existing lawsuit if the defendant believes that this third party is wholly or partially responsible for the plaintiff's claim. The primary goal is to shift liability, claim an indemnity, or seek a related remedy. So these proceedings are governed by Order 1 of the Civil Procedure Rules. The key goal is to prevent a multiple overlapping lawsuits by ensuring all liable parties are addressed in a single trial. So that is the key takeaway. If you are ever asked, why do you do third-party suits? What is the rationale? The rationale is to avoid multiple and overlapping lawsuits. Okay. What is the process? Application for leave is mandatory. A defendant cannot simply drag a third party into a suit. They must apply to the court for permission through leave by filing a chamber summons supported by an affidavit. This must generally be made within 14 days of the close of pleadings. Then serve the third party notice. If the court grants the application, the defendant issues and serves a formal third party notice along with the original plaint, responses, and appearance. The third party must evaluate the claims, and if they wish to contest them, enter an appearance in court within the time frame stipulated in the notice, usually 15 days from service. And failure to respond, if the third party fails to appear or respond, it is legally taken as an implied admission of both the plaintiff's claim against the defendant and the defendant's claim against them. They will be bound by any resulting judgment. Okay, so that is it. It is a straightforward scenario. But what happens where the defendant or where the third party is the government? Have I analyzed this part clearly? Let me see. Notice to government as third parties. If you read Order 1, Rule 16 of the Civil Procedure Rules, notice to government as third party. Notwithstanding anything in Rule 15, leave to issue a third party for service on government shall not be granted unless the court is satisfied that the government is in possession of all such information as it reasonably requires as to the circumstances in which it is alleged that the liability of the government has arisen, and as to the departments and officers of the government concerned. So whenever you're drafting a third party application and there is the government involved, so remember, the examiner will be keen. The exams are being marked by advocates. So they must see that how have you attempted to prove to the court that the government is in possession of all such information, or it is this officer in this department who is in charge of this information. This to avoid unnecessary dragging the court, the government in saving the public money's angle. So joinder of parties and misjoinder. Joinder of parties, we will analyze joinder of parties in criminal litigation in a detailed manner, because joinder of parties was tested in April criminal litigation paper, and many students felt it a challenge. There was a minor of 17 years old, there was an adult of 19 years old. They participated in commission of an offense, of a crime. So students were confused. How do you treat a minor who has committed an offense in custody, not in custody, in collaboration with adults? How do you read through the ODPP guidelines on child prosecution? Can you do plea bargain agreements in sexual offenses matters? Those are the things. What is diversion? When the DPP does not want to take you under the powers that he have, the power to charge. Okay, so we will analyze that part clearly. But when it comes to the civil litigation part, joinder of parties is allowed, and misjoinder is still allowed because you do an application now where you are amending. Okay, so that was what the examiner expected to have covered in topic 5. Then we have commencement of suits. We have various pleadings by which litigation is commenced and answered. We have plaint, statement of claim, memorandum of claim, originating summons, originating motion. We have petition, election, constitutional, matrimonial causes, and winding up proceedings. Okay, so in orals, you can be asked, kindly give us various pleadings that are used by a litigant in commencing a suit. So there is a plaint, statement of claim, memorandum of claim in employment matters, originating summons, originating motion. I believe that was the previous application that was used in before the Mutunga rules came to introduce originating motion. Mutunga rules brought forth the petition angle. So generally, an originating motion or originating notice of motion is a primary legal document used to commence civil court proceedings. This is not helpful. You will typically file an originating motion when seeking judicial review, where you are challenging a decision, action, or inaction by a government body or public official, or you are enforcing constitutional rights, bringing a case regarding a breach or threatened breach of fundamental rights, or a specific parliamentary action or civil procedure rule requires this exact mode of commencement. So an originating motion clearly outlines the specific law or rule under which the application is being made, the concise grounds or reasons for your application, the exact orders or remedies you are seeking from the court, the parties involved, and the accompanying documentations. Let me read Kenya law a link to that effect. There is a decision. Let us see whether it has addressed the same. 2022 decision. The applicants filed the notice of originating motion filed under Order 37 of the Civil Procedure Rules. So let us read Order 37. Order 37 of the Civil Procedure Rules. How does it answer our question? Order 37. I'm almost. Order 37. I'm in Order 36. Originating summons. So the courts are interpreting originating a motion to refer to originating summons. Okay. Okay. What are the key contents of each document? What if now you have been told to draft? Do you know what forms a good example of each? Let us start with the plaint. We look at various parts of a plaint. So when you have been told to draft a plaint, you have the title, the name of the court, the names of the parties, description and addresses. You have jurisdiction details, a statement explaining why the court has territorial or pecuniary authority, facts of the case in a clear chronological narrative. You have the legal claims, the specific legal basis or causes of action being brought against the defendant, and then you have the prayer for relief, and then that is it. If you look at statement of claim, this is used in small claims court. It is a form. It is a prescribed form. So generally it shows the parties, the facts, the cause of action and the relief being sought. Then there is memorandum of claim. How do you draft it? Memorandum of claim for employment matters. So generally a memorandum of claim is a formal legal document that outlines the details of a dispute, primarily used in employment or labor courts to institute a lawsuit. If you are filing a labor or employment dispute in Kenya, the following components in a memorandum of claim must be visible. The title, introduction. This is a summary statement of the relationship between the two parties. E.g., when employment started, what was the job title and what was the monthly salary? Do you have the statement of facts? Give a chronological numbered list of the events that led to the dispute, such as circumstances surrounding unfair termination, then issues in dispute, a clear breakdown of the specific legal questions the court needs to resolve, and then the reliefs being sought. Then, how do you draft an originating summon? Originating summon. Kenya. It is loading. Okay, there is a blog that has been done by Africa Law Center, where generally when you are drafting and originating summons, you have the case title, in the matter of the Limitation of Actions Act, and in the matter of land parcels reference number, you have the parties, the title, originating summons, being brought under which provisions of the law. Let these parties or this person or this PO box number enter appearance within 15 days after service of this summons, which is issued on the application of who claims to have acquired land reference herein after called the suit land for orders that the applicant be declared to have become the legal owner entitled by adverse possession. This summons is supported by the affidavit of RR on other grounds to be adduced at hearing. Then you attach the supporting affidavit. So it is very crucial to mention the nitty-gritties as compared to rushing through. How do you draft a petition? What are the key components of a petition? What is the key? What are the key components of a petition? Let us look. Let me see. Okay, a sample. Okay. It is giving me a summary of petitions in Parliament. Let me summarize to constitutional. So when you are drafting constitutional petitions, these are the parts that the examiner will expect to see. They'll expect to see the court heading in the matter of various clauses of the constitution that you are alleging. Who are the parties? Statement of facts. This is a clear, numbered chronological sequence of events detailing exactly what happened. Then you have constitutional violation allegations, a specific list of the constitutional articles and sections. Then substantive questions for determination, then jurisdiction and locus standi, and any other exhaustion of remedies and prayers that you are seeking. You can seek various prayers like declarations. These are statements that a specific action or law is unconstitutional. You can also seek injunction. These are orders stopping a specific action. You can also seek for damages on compensation for rights violation. Then you attach a sworn affidavit signed by the petitioner, confirming that the facts stated in the petition are true to the best of their knowledge. So that is generally how you will draft a petition. So failure to add constitutional violation allegations, that is the rider that will make you lose majority of the marks. So generally, you can also be told to give pleadings that are used in replies. So there is defense. You can use defense and counterclaim. You can use defense to counterclaim. You can use reply to defense. You can do reply to defense and defense to counterclaim. You can do answer to petition. You can do answer to petition and cross petition. You can do response to petition. And you can do replying affidavit and statement of grounds of opposition under Mutunga rules. Okay. Statement of grounds of opposition. Let us look at that. Statement of grounds of opposition. In Kenya, a statement of grounds of opposition is a legal document filed by a respondent to oppose an application, such as a notice of motion. It details the specific legal and factual reasons why the court should dismiss the applicant's request. This is under Order 51, Rule 14 of the Civil Procedure Rules. Okay. A respondent can choose to file a replying affidavit, grounds of opposition, or both. This must be filed and served on the applicant at least 3 clear days. So typical grounds of opposition include the following. Grounds of opposition typically challenge procedural irregularities or legal foundations without introducing new sworn evidence. Common grounds include 1. There is an abuse of court process. The application is filed in bad faith, is meant to delay the case, or is a frivolous attempt to litigate matters. Lack of merit. The facts and laws cited by the applicant do not support the prayers they are seeking. Defective pleadings. The application fails to cite the correct laws or fails to meet the threshold required by the Constitution or relevant statutes, and lack of locus standi. The applicant does not have the legal right or standing to bring the specific claims. You can also have a look at an example of how you draft a ground of opposition. This will also, okay, let us look at it. I will read through because you have seen where it is used. This was used in the High Court of Kenya at Nairobi, Constitutional and Human Rights Division, in the matter of the enforcement of the Bill of Rights under Article 22 of the Constitution of Kenya, and in the matter of the alleged contravention of Article 19, 20, and 21 between parties. Grounds of opposition in respect of notice of motion dated this date. Take notice that the first intended interested party will oppose the notice of motion dated 13th April 2015 on the following grounds: that the petition makes no allegation of any infringement or violation of the petitioner's rights by the first intended interested party, that the first respondent has not filed any cross petition or shown precisely what provision of the Constitution has been infringed. Then you sign off and to be served upon. Okay. Then let me look. At least we have understood where a ground of, you can either do a replying affidavit and you can also do a statement of grounds of opposition under the Mutunga rules when you want to challenge an application that has been brought maybe by a notice of motion. Okay. Let us see various replying stages of a succession matter. Remember, I told you that this will be an extensive discussion. we must understand the various probate procedures at this part and various documents to file. Okay. We must understand the various procedures to draft. I'm analyzing various blogs to see the blog that has answered our question. Good. So this is it. So in a succession matter in Kenya, there are specific replies or responsive pleadings required. Okay, and this is anchored under the Probate and Administration Rules and the Law of Succession Act. We start with replying to a petition of grant. This is where we have the objection stage. When a person petitions for a grant of probate or letters of administration, any aggrieved party must wait for its gazettement to object. The succession rules require a tripartite response structure. This is where they have Form 28 and PA 50, objection, filed to lodge a formal protest against the making of the grant to the petition. Then you have an answer to petition. This is a detailed response outlining the specific grounds of objection, e.g. fraud, omission of beneficiaries, or an invalid will. Then we have cross petition. This is an administrative cross prayer where the objector asks the court to grant the letters of the objection or probate to themselves or a preferred alternative beneficiary instead. Okay? Then 2. Replying to interlocutory applications. Disputes arising after a grant has been issued, such as distribution disputes or requests to revoke a grant, are brought via a summons. This is where we have a replying affidavit, the legal representative to any summons, e.g. summons for confirmation of grant or summons for revocation of grant, is a replying affidavit. This document details the respondent's facts, evidence, and opposition to the application. Then we have what we call further affidavit or response to replying affidavit. If the applicant wishes to challenge the new issues being raised in the respondent's replying affidavit, they file a supplementary response to it. Then how do you reply to citations? A citation is a court order demanding that a person either accept or refuse a grant or prove a will. You first have to appearance to citation, person to Form 37. The primary step where the cited party must appear and must enter an appearance at the probate registry within the time frame stipulated in the citation, usually 15 days. Then you do an answer to citation. If the cited party disputes the citation, they file a formal answer detailing why the citor is not entitled to force the administration or why they have delayed the process. So that is basically it. So we have not ignored cross petitions and answers to petitions. Okay. Topic 7. Interlocutory applications. Applications under Order 40. This is where we have temporary prohibitive injunctions and Anton Pillar orders. Excuse. We can't ignore this part because examiners are prone in asking various confusing elements of injunctions. So we'll start one by one. We start with Order 40 requirements. Have I analyzed the same? That is the key determinant. Yes, I have analyzed Order 40 on temporary injunctions and interlocutory orders. I read verbatim. So, Order 40 reveals the cases in which temporary injunction may be granted, where in any suit is proved by an affidavit or otherwise that any property in dispute in a suit is in danger of being wasted, damaged, or alienated by any party to the suit, or wrongfully sold in execution of a decree, or that the defendant threatens or intends to remove or dispose of his property in circumstances affording reasonable probability that the plaintiff will or may be obstructed or delayed in the execution of any decree that may be passed against the defendant in the suit. The court may by order grant a temporary injunction to restrain such act or make such other order for the purpose of staying and preventing the wastage, damaging, alienation, sale, removal, or disposition of the property as the court thinks fit until disposal of the suit or until further orders. So basically, my analysis proceeds to say that Order 40 is applied as a strict evidence-driven preservation regime. The applicant must satisfy the Giela, Mrao, and Nguruman test for interlocutory injunctions and must also comply with the hard timelines on ex parte injunctions. Okay, this is why we have 14 days plus service within 3 days and the 12-month lapse rule, failing which the injunction dies automatically. So generally Order 40 Rule 1 provides that the court may restrain waste or alienation and wrongful execution or sale or disposal intended to obstruct execution. Then you have Rule 2 of Order 40, injunction to restrain breach of contract or other injury, and the court may impose terms such as undertakings as to damages and security and accounts. Then you have Rule 4, ex parte only if delay would defeat the object and reasons must be recorded. Ex parte injunction maximum 14 days, extendable only once for up to 14 days by consent or through court order. Service within 3 days of the order. This is why you serve the order application plus the pleadings. And the failure to do this it leads to automatic lapse. Injunction applications to be heard within 60 days unless extended for good reasons. Rule 6 provides that if suit is not determined within the 12 months of grant, injunction lapses unless the court orders otherwise for sufficient reason. So basically, I'm looking for the test that the examiner can ask you. Under Order 40, you only get interim preservation if you proved the 3 sequential hurdles. We have the Giela decision, the landmark decision, that provided for prima facie case, irreparable harm, and balance of convenience. This was tightened by the Murao decision that describe what amounts to prima facie case, and the Nguruman decision provides that the hurdles are sequential. No prima facie case ends the inquiry. Irreparable harm must be demonstrated and not alleged. So the panel can ask you, do you clearly identify the reason why the three decisions are landmarks? Mrao emphasized on what prima facie case means. Giela provided the three tests, prima facie case, reparable harm, and balance of convenience. But what did Gurman came to do? The Gurman said that these hurdles are sequential. No prima facie case ends the inquiry. Okay? Irreparable harm must be demonstrated and not alleged. So it came to emphasize. Okay? So prima facie case with a probability of success, irreparable injury that cannot be adequately compensated by damages, and if in doubt, the court will decide on the balance of convenience. Then, Murao decision. The core holding, as used in injunction rulings, is that a prima facie case is more than an arguable case. On the material presented, there must be an apparent right which has been infringed or is being threatened so as to call for an answer or rebuttal. Okay? You must show a recognizable legal or equitable right. Do you have ownership of the same? Do you have possession? Is there contractual entitlement, statutory protection, and a credible infringement threat attributable to the respondent? Mere allegations they will evict me, they are trespassing without linking evidence frequently fail this test. Okay? Prima facie case must be shown. Registered proprietorship and possession heavily influence the outcomes. Then, Gurman decision. The limbs are sequential, not a menu. If you fail on prima facie case, the court must not move to reparable harm or balance of convenience. Irreparable harm is not inferred from a prima facie case. It must be actual, substantial, demonstrable, not speculative. So courts expressly describe the sequential approach and require this demonstrable harm. Where harm is speculative or compensable, injunction is refused even if there is a dispute. Okay? How do you draft a good application that seeks for a temporary injunction? A very common problem question in civil litigation papers. Introduce the case title, the parties. Then you draft a notice of motion. This is provided under Order 40, Rule 1, 2, 4, 7 of the Civil Procedure Rules and all enabling provisions. That this application be satisfied urgent and heard ex parte in the first instance. That the grounds that you are relying upon, the prayers that you are seeking, is that pending inter partes hearing, this honorable court be pleased to grant a temporary injunction restraining the defendant, whether by himself, agent, or servants, from doing the following in respect of this property. That pending hearing and determination of this suit, a temporary injunction do issue in the same terms. What are the grounds that the examiner will expect to see? Property or right in dispute is in danger of waste or alienation or dissipation. Defendant is threatening breach or injury. Applicant has a prima facie case. Damages will be inadequate and balance of convenience favors preservation. Okay? Then you do a supporting affidavit reiterating the grounds that we said the examiner will look at. And that will have answered the general applications are under Order 40. What are Anton Pillar orders? Anton Pillar. What is the test? So an Anton Pillar order is an exceptionally highly invasive civil court injunction. It allows a plaintiff to search a respondent's premises and seize incriminating evidence without prior warning. Its primary purpose is to prevent the intentional destruction or concealment of critical documents. You have to prove the following before granting. Strong prima facie case. The plaintiff must demonstrate an extremely strong initial legal case. Severe damage. The actual or potential damage to the plaintiff. There is a landmark, a precedent. The concept originates from the landmark decision, a UK case of 1975, Anton Pillar KG versus Manufacturing Process Limited. You can have a look at how courts have tried to apply the same. I'm looking for how it is now tried that for an Anton Pillar order to be granted ex parte, three conditions must be fulfilled. If the examiner fails to see these conditions, you fail. There must be an extremely strong prima facie case. This being borrowed from Soroya Investments Limited versus Barclays Bank Kenya Limited 2017. There must be an extremely strong prima facie case. The damage or potential or actual must be serious for the applicant, and there must be clear evidence that the defendant has in his possession incriminating documents or thinks that there is a real possibility that they may destroy such material before any application inter partes can be made. That is the direct interpretation of what amounts to Anton Pillar orders. Let us look at various tests for Mareva injunction. Is it a different test? Because you have seen for Anton Pillar, prima facie case, serious damage, and the third test is to prove that the documents are in possession of the defendant. What about Mareva? For Mareva, this is also known as a freezing order. It is a powerful interlocutory court order that prevents a defendant from dissipating, transferring, or hiding assets. Its primary purpose is to ensure that a successful plaintiff is not left with an empty or unenforceable judgment. Let us look at various principles that have been formulated in various decisions to grant the same. Good. If you read the decision known as PKF Kenya LLP, Onjor and two others, it says that the principles governing Mareva injunctions are now well settled. The grant of a freezing injunction is governed by principles quite distinct from those laid down for ordinary interim injunctions. Maybe you can unmute because I can't see you.
Yes, Victor.
Yes.
Come again on that, please.
The case, because okay, let me give you the case that where this clause was lifted from. That will be appropriate. See International Airport. So C ni ile ya kuona, ona International Air Transport Association, and another versus Akarim Agencies Company Limited and two others, 2014. International Air Transport Association and another versus Al Akarim Agencies Company Limited and two others. Hiyo ya pili yenye sasa nimefungua inaitwa PKF Kenya Limited, Kenya LLP versus Onjor and two others, commercial case E502 of 2025. It was a ruling. So in this, the court borrowed the following. The grant of a freezing injunction is governed by principles quite distinct from those laid down for ordinary interim injunctions. Before granting a freezing injunction, the court will usually require to be satisfied that 1. The claimant has a good arguable case based on a pre-existing cause of action. The claim is one over which the court has jurisdiction. The defendant appears to have assets within the jurisdiction. There is a real risk that those assets will be removed from the jurisdiction or otherwise dissipated if the injunction is not granted. And E, there is a balance of convenience in favor of granting the injunction. The court can also order disclosure of documents or the administration of request for further information to assist the claimant in ascertaining the location of the defendant assets. So these, for this injunction to be applicable, we have seen the court stressing on a jurisdiction angle, arguable case, and balance of convenience. Those are the key takeaways when it comes to Mareva injunction. The same is provided under Order 39 of the Civil Procedure Rules. Interpleader proceedings we have discussed on the same. In 2022, there was a question on discovery and inspection. Did students really understood what we refer to discovery and inspection? Where do you file these documents? Let us look at directly what the Kenya law provides. So it is bringing up some decisions. Let us click and see. Let us look at it. So basically, if you read section 22 of the Civil Procedure Act, it says that subject to such conditions and limitations as may be prescribed, the court may at any time, either on its own motion or on the application by either party, make such orders as may be necessary or reasonable in all matters relating to the delivery and answering of interrogatories, the admission of documents and facts, and the discovery and inspection, production, impounding and return of documents or other material objects producible as evidence. The court has the power to summon any person to produce such documents or adduce evidence as the case may be. So discovery will not be ordered in respect of an irrelevant allegation in the pleadings, which even if substantiated, could not affect the result of the cause of action, nor in respect of an allegation not made in the pleadings or fact or particulars, nor will delivery be allowed to enable the party to fish for witnesses or for a new case. Each case must be considered according to the issues raised, but where there are numerous documents of slight relevance and it will be oppressive to produce them all, some limitation may be imposed. So basically, what is the key takeaway if you are asked during the panel? Discovery and inspection in Kenya civil litigation are critical pre-trial procedures used to compel the disclosure and examination of relevant evidence, governed by Section 22 of the Civil Procedure Act and Order 11 of the Civil Procedure Rules. These tools ensure fairness, level the litigation field, and prevent trial by ambush. Okay. So discovery requires a party to formally list all relevant and non-privileged documents within their possession, custody, or power. So what are the procedure that you have to follow? We have voluntary versus compulsory. While orders 4 and 7 mandate initial disclosure alongside pleadings, a party can apply to the court to compel further discovery if the opponent holds back evidence. The disclosing party often verifies their list using a sworn affidavit, breaking items into schedules of what they possess and what they used to have but have no longer control of the same. Inspection of documents. Once documents are discovered, the opposing party has a legal right to physically or digitally examine them and take copies. This is where we have notice to inspect. Under Order 11, the party seeking inspection serves a formal notice. Timeline. The receiving party must respond within specified timeframes, typically stating a time within 7 days and a location where the documents can be reviewed. We have interrogatories. This is discovery via written questions delivered to the opposing party, who must answer them under oath via an affidavit. Parties must seek leave or permission from the court before delivering interlocutors. So basically, the consequences of non-compliance. If a party fails to comply with that discovery or inspection notice, the court may reject the defaulting party's right to use those documents as evidence later, and they draw adverse inferences against them, presuming the hidden evidence will damage their case, and order the defense to be struck out or the suit be dismissed entirely. The other key factor that I wanted to finalize before we go to the other topic 8 in another previous, not in another subsequent class, because we will want to shift gears to another unit, we will focus on the Evidence Act, and in particular evidence cross-examination, evidence in chief. We read verbatim what the Evidence Act provides. And in this situation, I'll be forced to share the Evidence Act so that you can also read on your own, because this part forms a critical part in orals and also a critical part in trial advocacy. So let me project the same once it is opened. Then we will take a break. We log into the other class. Then we resume and do an analysis of LPM, because for LPM I've managed to do the full course outline and answered questions arising from the same, because that is a free mark. Or rather, before LPM, Ringera, is there a need to to do kwanza LPM sahi ama kwanza tuingie the substantive ones zenye watu wanaanguka? Do we go to professional ethics or we go to netwaje commercial transactions?
What do you think? We can go to
commercial transaction because in my view commercial transaction ikumbuka ilikatizwa katikati, unaona, people do not have a flow of the same, unaona, people don't know what is happening. Ama in the alternative, because remember for professional ethics, remember we have done Advocates Act analysis in its entirety. I've finished in SOPEC rules, rule by rule, unaona. For Advocates Act inakuwa that once you have mastered the Advocate Act and the SOPEC rules and you know the landmark decisions zenye may bring some tests zenye unaweza anguka ikiulizwa kama swali, unaona, hapo ndio sasa unaweza mess, unaona. But in my view LPM is a straightforward pass because with the course outline na flying notes uko eligible to pass. Trial advocacy pia ni sure bet juu ni the act of litigation in its own. Now sasa hii evidence act na other two factors zenye tuna borrow from professional ethics tuko guaranteed of a pass in trial advocacy. When it comes to probate, remember tumefanya Law of Succession Act all the way up to section 29. We are to start with section 29. So these are the things zenye sitaki zi stall behind because even in orals tutaulizwa pia hizi sections. So in my view, once we have done this substantive ya civil litigation of which tumefanya vizuri, tutaingia one for commercial transaction. Remember for commercial transaction, tukiona the course outline required us to master this procedure, tuna search your procedure on our feet. We answer juu recording inaonyesha screen yote vizuri for a person to follow up, then tukoza tumemaster hiyo process inataka nini ya commercial transaction. Tukimaliza commercial transaction bado ni the full day leo, tutaingia nini? Tutaingia
also I have the orals ready.
Good. For current affairs.
A few tunaweza pitia.
Kama nikupe hii chance, tumesema ni break alafu sasa tukiresume uingie sasa na hizo current affairs. So you'll take the standard for the current affairs, then we jump to the cause outline ya commercial transaction, we see it. Then after commercial transaction I was proposing tuangalie conveyancing. Do I have a reason why conveyancing? Juu conveyancing pia ni many procedures na pia tukizijua na wafit itatusaidia. Unaona hizo angles?
Yes,
so that is how we will. Una propose saa ngapi? Juu ni kuchange tu class. Mimi niko standby leo. Nilala enough, niliava enough.
Maybe 10:20.
Sawa. Hata tuweke 10:20. So hii tuta resume cross examination na examination in chief. Ama tupitie. Unajua pia kuprocrastinate ni noma. Haya. Sasa screen yangu ime freeze juu nimeshinda screen time sana. So what I will do, let me read through it. Alafu juu pia nyinyi mko allowed pia ku open the same. Tupitie tuone what is actually happening kwa hizi maswali za cross examination na examination in chief. What does the act provide? What does the act? Okay. Tutaangalia mpaka competency of a witness but in a different part. The Evidence Act is very critical. The examination of witnesses are good. Part 3 of the Act. Part 3 of the Act. So let me read briefly. Section 144 of the same courts to decide as to the admissibility of evidence. Then we have section 145 provides for type of examination of witnesses. So this is where we are interested in. The examination of a witness by the party who calls him shall be called his examination in chief. 2. The examination of a witness by the adverse party shall be called his cross-examination. 3. Where a witness has been cross-examined and is then examined by the party who called him, such examination shall be called his re-examination. Okay. Order and direction of examination. Section 146. Witnesses shall first be examined in chief, then, if the adverse party so desires, cross-examined, then, if the party calling them so desires, re-examined. Subject to the following provisions of this Act, the examination in chief and cross-examination must relate to relevant facts, but the cross-examination need not be confined to the facts to which the witness testified in his examination in chief. The re-examination shall be directed to the explanation of matters referred to in cross-examination. Okay? So acha kwanza nirudie hapo hiyo part 2. Subject to the provisions of this Act, the examination in chief and cross-examination must relate to relevant facts. But the cross-examination need not be confined to the facts to which the witness testified in his examination in chief. The re-examination shall be directed to the explanation of matters referred to in cross-examination. And if new matters is, by permission of the court, introduced in re-examination, the adverse party may further cross-examine upon that matter. The court may in all cases permit a witness to be recalled either for further examination in chief or for further cross-examination. If it does so, the parties have the right of further cross-examination and re-examination respectively. Okay. Part 4 of the Act, questioning of witnesses. Section 147, person called to produce a document. A person called to produce a document does not become a witness by the mere fact that he produces it, and cannot be cross-examined unless and until he is called as a witness. 148, witness to character. A witness to character may be cross-examined and re-examined. 149, what is the meaning of leading question? Any question suggesting the answer which the person putting it wishes or expects to receive, or suggesting a disputed fact as to which the witness is to testify is a leading question. 150. Leading questions in examination in chief and re-examination. Leading questions must not, if objected to by the adverse party, be asked in an examination in chief or in a re-examination, except with the permission of the court. 2. The court shall permit leading questions as to matters which are introductory or undisputed, or which have, in its opinion, been already sufficiently proved. So, leading questions in examination in chief and re-examination, we have seen various key takeaways. That if leading questions must not, if objected to by the adverse party, be asked in an examination in chief or in a re-examination except with the permission of the court. So leading questions will require permission of the court in examination in chief and re-examination if the same is objected by the adverse party. And the court shall permit leading questions. These are the exceptions that forms grounds where leading questions can be allowed if they are the introductory or undisputed. 151. Leading questions in cross-examination. Leading questions may be asked in cross-examination. 152. Examination as to whether certain formal matters are contained in writing. Any witness may be asked whilst under examination whether any contract or grant or other disposition of property as to which he is giving evidence was not contained in a document. But if he says that it was, if he is about to make any statement as to the contents of any document which, in the opinion of the court, ought to be produced, the adverse party may object to such evidence being given until such document is produced, or until facts have been proved which entitled the party who called the witness to give secondary evidence of it. Cross-examination as to previous written statements. 153. A witness may be cross-examined as to previous statements made by him in writing or reduced into writing and relevant to matters in question without such writing being shown to him or being proved. But if it is intended to contradict a witness by a previous written statement, his attention must, before the writing can be proved, be called to those parts of it which are to be used for the purposes of contradicting him. Cross-examination as to credibility. When a witness is cross-examined, he may, in addition to the questions herein before referred to, be asked any questions which tend to test his accuracy, veracity, and credibility. 2. To discover who he is and what is his position in life. To shake his credit by injuring his character, although the answer to such questions might tend directly or indirectly to incriminate him, or might expose or tend directly or indirectly to expose him to a penalty or forfeiture. Compulsion to answer questions as to credit. If any questions asked under 154 for the purposes of affecting the credit of the witness relates to a matter relevant to the suit or proceeding, the provisions of 128 of this Act shall apply. Cross-examination of accused person. 156. A person charged with an offense and called as a witness for the defense may be asked any question in cross-examination, notwithstanding that the answer may tend to incriminate him as to the offense being charged. So it appears that Ringera, in my view, will have to do an extensive analysis of the Evidence Act. Hiyo tu ndo naona will be the savior, because if you are keen on trial advocacy past papers, you realize that the examiner is interested pia na how various documents are to be produced in court. How do you produce documents in examination during examination in chief? Unaona vitu kama hizo. So in my view, Evidence Act will require an extensive research, alafu tuweke the procedure behind these provisions. Your view on that, twende break. Okay.
So hii part ni well loaded. So hii part tunatoka leo.
Sawa.
Hii part tunatoka leo.
Hii part hii tutahitaji session ya the art of cross. Hiyo ndio itakuwa title. The art tuifanye kesho. Juu ni research leo.
Let me share tumekolea hapo.
Okay, sawa, thanks. Sawa. So let us take a break, alafu tuta resume. Umesema 10:20. Sawa, acha nilingie hiyo next class hadi. Let me end the recording.